Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss the topic of res judicata, which the final year students they have to discuss in the seminar on the next Saturday. So, section 11 of the CPC deals with the res judicata, and the main principle is one decision per one case is enough. That's all. So, res judicata pro vexare. Nobody should be vexed with the same litigation on a number of times. Just like double jeopardy as per the Constitution of India. This all you know very much. So, very recently, Honorable Supreme Court of India, in the case of S.Ramachandran Vs S Nagabhushna 2022, in civil appeal numbers 7691 to 7694 by 2022 on 19th October 2022, just 2 days yesterday, I think. 2 days back, Justice Dinesh Maheshwari and Anirudh Bose, they held that res judicata applies not only to the subsequent proceedings but also subsequent stage of the same proceeding. This you have to understand. Res judicata, normally we know if one case is filed, if that is decided on the same issue, second case cannot be filed at any other place. But here the Supreme Court stated that it applies to the subsequent stage of the same proceedings also. How it happened? Let us quote the facts of the case so that you will appreciate it very much. So this Suryadevara Nagabhushna Rao, actually yes, Nagabhushna Rao, he filed OS number 368 by 95, if I am correct. He filed an OS in the court, in the Vijayawada court, right? The division bench is Suryadevara Ramachandran Rao, right? So 368 by 95, I am correct. So wherein the appellant, Mr. Ramachandran Rao, he is R3. Actually, it is a suit for separation or partition, suit for partition. I think they are brothers. I am not sure, but I think they are brothers. Suit for partition. And what happened is, in this case, the decree, actually a compromise memo was filed before the court and a decree obtained. Later, this Ramachandran Rao, he has Nagabhushna Rao, he has not agreed for the compromise. He stated that the decree was obtained by fraud, and therefore he has given GPA to his wife. Since he is far away at some other place, GPA, this is Hemalatha. So she has become the GPA holder. Now OS 368 by 95, once again the trial is going on. The GPA was given to his wife, right? Now on 25/1/1997 he has given the GPA. Now the case is going on. And as GPA, she filed 3 original suits. That is 388 by 97. That's why I put the date 25/1/97. After getting GPA, she has filed 3 suits. Number 1, 388 by 97. That is a declaration of declaration of the title, possession, and also main profits. Then OS number 104 by 98. That is a rendition of accounts or suit for accounts. Third one, 445 by 98, that is partition and also main profits in other property. This, civil case, it goes for years together. In the meanwhile, the Hemalatha madam, she studied law and she has obtained the law degree and she has enrolled herself as an advocate. Now, using the provisions of Section 32 of the Advocates Act, that is, the court can allow anybody, even not a lawyer, to personally appear for appearance. Yes, allowed. Then she started cross-examination of the witnesses. This was objected to by the other party. So therefore, they went to the high, of course, they filed the objection memo, and the trial court, yes, held that she can, as per 32 of the Evidence Act, she can appear, she can file her appearance before the court, but she cannot conduct the trial. No doubt she is the GPA, but she cannot conduct. No, even though she appears in person, that section 32 is allowed only for the appearance, that's all, not for the cross-examination. But she said, it's an appearance in person. If I appear in person, yes, I have got every right for cross-examination. Therefore, the matter objection. The objection is actually not allowed by the trial court. Then they went to the High Court. High Court, okay, the High Court of Andhra Pradesh, they said that, no doubt, at the time of GPA, she was not an advocate. After that, she became an advocate. As an advocate, she can prosecute. Like that, they have given. That means they have reversed the orders of the trial court. They have allowed her for the continuance as an advocate also. But aggrieved by this, Mr. Ramachandran Rao, who was R3 in the previous case, he approached the Honorable Supreme Court of India. Supreme Court of India clearly said that once she was declared as a GPA, she has the character of GPA. Subsequently, even though she gets a law degree, she cannot appear. It is barred by the so-called res judicata. Very clearly, Supreme Court held, and therefore they have allowed the appeal. And actually, the trial court submission has been continued. Now she has to apply, get another service of another advocate. So what I want to tell you is, res judicata applies not only to the subsequent proceedings but also to the subsequent proceeding in the same suit also. This is what you have to learn. Very important and typical judgment. Please go through the judgment. S.Ramachandran Rao versus S. Nagabhushna Rao 2022, and it happened in Andhra Pradesh, particularly near our Vijayawada. Please go through the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.